An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Printz versus United States, 1997. New York versus United States, 1992, held that Congress could not commandeer or force state legislatures to take certain actions, such as enacting new legislation. Printz versus United States, 1997, extended this doctrine and held that Congress could not commandeer state executive branch officials, such as a sheriff, to implement a federal program. Provisions of the Brady Handgun Violence Prevention Act require the Attorney General to establish a national system that would allow federal firearm dealers to instantly check the background of prospective handgun purchasers. While that electronic system was being developed, the law commanded the Chief Law Enforcement Officer, or CLEO, of each local jurisdiction to conduct such checks and perform related tasks on an interim basis. The law was challenged by several sheriffs, including Jay Printz of Ravalli County, Montana, and Richard Mack of Graham County, Arizona. Printz argued that the federal government cannot force him to perform background checks and delay people in his community from purchasing firearms. The Supreme Court sharply divided 5-4. Justice Scalia wrote the opinion for the court, and Justice Stevens wrote the principal dissent. They disagreed on everything. First, Justice Stevens wrote that in the early days of the Republic, Congress enacted statutes that require participation of state officials in federal law implementation. Justice Scalia, however, countered that these federal obligations were imposed only on state judges, who could be forced to apply federal law. Justice Scalia cited the Supremacy Clause in Article 6, Clause 2. It provides that, quote, "The laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby." In contrast, Article 6, Clause 3 states, "Executive and judicial officers of the several states shall be bound by oath or affirmation to support this Constitution." Thus, argued Scalia, the Constitution imposes a higher obligation on state judges than it does on state executive branch officials. Second, the dissent contended that even if New York versus United States was correct, and state legislatures cannot be commandeered, state executive branch officials can. Quote, "The fact that the framers intended to preserve the sovereignty of the several states," Justice Stevens wrote, "simply does not speak to the question whether individual state employees may be required to perform federal obligations." Justice Scalia rejected this distinction. Quote, "While the Brady Act is directed to individuals," Scalia said, "the law is directed to them in their official capacities as state officers. It controls their actions, not as private citizens, but as the agents of the state." Study guide. Is there any principal distinction to be made between federal commandeering of state legislatures and state executive branch officials? Third, Justice Stevens cited recent examples where Congress may have ordered state executive branch officials to take certain actions. Justice Scalia dismissed the relevance of these recent practices. Quote, "Their persuasive force," he said, "is far outweighed by almost 2 centuries of apparent congressional avoidance of the practice." Finally, the dissent argued that the Brady Act was valid, quote, "because the 10th Amendment imposes no limitations on the exercise of delegated powers, and the Necessary and Proper Clause was an affirmative delegation of power in Article 1 that provides ample authority for the congressional enactment." Justice Scalia responded that the Necessary and Proper Clause is, quote, "the last best hope of those who defend ultra-vires congressional action." He made clear what Justice O'Connor had implied in New York versus United States. Courts must separately ask whether a law is both necessary and proper. Justice Scalia stated the rule succinctly. Quote, "When a law for carrying into execution, the Commerce Clause, violates the principle of state sovereignty, it is not a law proper for carrying into execution the Commerce Clause, and is thus, in the words of the Federalist, merely an act of usurpation, which deserves to be treated as such." The Brady Act provision may have been a necessary means to regulate the interstate firearms marketplace, but forcing sheriffs to perform background checks was not a proper exercise of federal power because it violates the principle of state sovereignty reflected in the 10th Amendment and other structural provisions of our Constitution. The Supreme Court would reaffirm the distinction between necessary and proper 15 years later in the Affordable Care Act decision, NFIB v. Sebelius, 2012.